Hi, I'm Tony Nunn, and I'm the National Sales Director for the Charles Darby Mortgage Bureau. Welcome to Module 2 of this series of protection planning modules, and if you have already watched Module 1, you will no doubt know that this module looks to identify what is available via the state system regarding the death of an individual and have a look at benefits available to those who may be impaired and unable to work. We will also cover statutory sick pay and support for mortgage interest. In addition, we will take a realistic look at death in service benefits, which are generally available as an employee benefit via the workplace and which, in my experience, is the most common objection for not purchasing protection policies when they are associated with mortgage planning. I will endeavour to show you some of the pitfalls in using this valuable benefit inappropriately and thus identify some of the issues that your client may not be aware of but may thank you for pointing out. Firstly, let's look at what the state might provide or have provided in the event of death. The first thing to note is that state benefits in respect of death went through a reform in April 2017, and so bereavement allowance, bereavement payment, and widowed parents allowance have all been superseded by bereavement payment support. The latter came into effect for deaths recorded on or after the 6th of April 2017. And bearing in mind that we tend to deal with living clients for mortgage purposes, I do not feel that we need to concern ourselves too much with the former. There is a DWP document detailing the changes regarding these benefits, which is now available for you to download or peruse via the CDMB portal under Documents, as well as a full DWP document of the benefits pertaining to bereavement support payment. However, let's take a closer look at it. Under eligibility, you may be able to get bereavement support payment if your husband, wife or civil partner died on or after the 6th of April 2017. You could be eligible if your partner either paid national insurance contributions for at least 25 weeks or died because of an accident at work or a disease caused by work. When they died, you must have been under state pension age, living in the UK or a country that pays bereavement benefits, and surprisingly, you can't claim bereavement support payment if you're in prison, and thankfully, you will not be advising inmates. So what can you expect to receive? You'll get a first payment in the form of a lump sum and then up to 18 monthly payments. There are two rates. Higher rate, first payment of $3,500 and a monthly payment of $350, and a lower rate of $2,500 and £100 a month. If you get child benefit, or if you don't get it but you're entitled to it, you'll get the higher rate. If you don't get child benefit, you'll get the lower rate unless you were pregnant when your husband, wife or civil partner died. You must claim within 3 months of your husband, wife or civil partner's death to get the full amount, and you can claim up to 21 months after, but your payments will be less. Any benefit will be paid directly to your bank or building society. So what if you're already receiving benefits? Well, because it's not means tested, bereavement support payment won't affect your benefits for a year after your first payment. After a year, any payment you have left over could affect the amount of benefit you're eligible for. And you must tell your benefits office or your local job centre plus when you start getting bereavement support payment. So in conclusion, there is some provision or assistance from the state, but the question that needs answering is it enough? It's safe to assume that the answer to that is no, and because of the short-term nature of the support and the rules pertaining to being eligible, it is probably better to disregard this for mortgage planning purposes and treat it as additional funding if you're lucky enough to receive it. But what if you haven't died, but are unable to return to work through a serious illness or accident which renders you incapacitated? In this regard, personal independence payment is a benefit that may become payable, but it's not a given and the individual will be asked to attend an assessment. So let's have a closer look. You may be able to get help with some of the extra costs caused by long-term ill health or disability, and if you're aged 16 to 64, you could get between £22 and £141 a week by claiming personal independence payment. The amount you get depends on how your condition affects you, not the condition itself. And you'll be assessed by a health professional to work out the level of help you can get, and your rate will be regularly reviewed to make sure you're getting the right support. To be eligible for PIP, you must be aged 16 to 64 and have a health condition or disability where you've had difficulties with daily living or getting around, or both, for 3 months, or expect those difficulties to continue for at least 9 months, unless you're terminally ill with less than 6 months to live. You must have lived in England, Scotland or Wales for at least 2 of the last 3 years and be in one of those countries when you apply. If you've recently returned from living in another EEA country, you might be able to get PIP sooner. You can get PIP whether you're working or not, and there are additional rules if you live abroad or if you're not a British citizen. So if you've been living abroad, you might still be able to get PIP. If you lived in another EU or EEA country or Switzerland, you can only get help with daily living needs. However, if you're not a British citizen, you must normally live in or show that you intend to settle in the UK, the Republic of Ireland, Isle of Man or the Channel Islands. Not be subject to immigration control unless you're a sponsored immigrant. You might still be able to get PIP if you're a refugee or have humanitarian protection status. As has already been advised, part of the eligibility process for this benefit will come by way of assessment, and in this regard, daily living difficulties will be explored. You may get the daily living part of PIP if you need help more than half of the time with things like preparing or eating food, washing, bathing and using the toilet, dressing and undressing, reading and communicating, managing your medicines or treatments, making decisions about money, engaging with other people. In this regard, the weekly rate for the daily living part of PIP is either £55.65 or £83.10. If you experience mobility issues, you may get the mobility part of PIP if you need help going out or moving around. For mobile difficulties, the weekly rate is either £22 or £58. And as mentioned earlier, eligibility for PIP is by assessment, and such an assessment is carried out by an independent healthcare professional to help the DWP work out the level of help required. Again, I think it is safe to say that there is some support from the state, but again, not enough if you want to continue to enjoy the property you're about to purchase, add to, and or continue some sort of acceptable lifestyle in addition to subsistence. So let's turn our attention to another myth which clients tend to believe. Statutory sick pay. The belief is that it is enough and that it will enable them to continue as if nothing has happened. However, the facts should be enough to discount this as an option because you only receive £89.35 per week if you're too ill to work, and it is only paid by your employer for up to 28 weeks. The primary qualification for eligibility for SSP is not too onerous, and it is as follows. Be classed as an employee and have done some work for your employer. Have been ill for at least 4 days in a row, including non-working days. Earn at least £113 before tax per week. Tell your employer you're sick before their deadline or within 7 days if they don't have one. Again, suffice to say that if your employer has no other benefits in relation to being off work, then this benefit alone will not allow for what is required as a homeowner and is very much a short-term measure. SMI. This is the last of the state benefits that I feel it is important to talk about, and that is because from the 6th of April 2018, the rules are about to change. Currently, it is classed as a benefit However, from the start of the new tax year, it will change to a loan from the state, which will then become repayable when you sell or transfer ownership of your home. To qualify, you must be out of work or of state pension age and get income support, income-based job seekers allowance, income-related employment and support allowance, universal credit or pension credit. There is a 39-week waiting period from the time you claim SMI until your first payment is made, unless you're getting pension credit, in which case you can get help immediately. So what will you receive? The government will pay interest on up to £200,000 of your mortgage, or up to £100,000 if you're getting pension credit. They will use a standard interest rate to calculate the amount they will pay, and it will be variable, so it may go up and down over time. The payments will normally be made directly to your mortgage lender, and there is no help available to help repay the capital. This is a pure interest-only option. With this being a fact, I believe that this is probably the biggest reason to arrange your own protection in the event of long-term illness or incapacity. Because of the change of status of SMI to it being loan-based as opposed to a benefit from the state, I do not feel that it should be explored any further. Suffice to say that if you want to see what is available, copy and paste the link below into your browser and have a look for yourself. The message we are trying to convey in this module is, are state benefits enough? It is safe to say that the state will provide something, but as you can see, it will not be enough to support a mortgage, let alone maintain the costs arising from the utilities, subsistence of the individual, or allow for an acceptable lifestyle should the unforeseen happen. I tend to prefer the adage that life is not a rehearsal, so you need to make the most of it. If you fail to protect yourself appropriately, there is another adage which springs to mind, and it is, life isn't worth living. Although that is always a tough debate to have with anyone. Lastly, let's have a look at the scourge of many a mortgage advisor, and that is death in service benefit. A valuable benefit, often inappropriately assumed as an acceptable vehicle by clients with which to provide funds to cover their mortgage in the event of death. With that in mind, do clients really understand what it is? In my experience, they tend to believe it is nothing more than a benefit payable by their employer via prescribed calculation related to their earnings, and payable when the employee dies, normally 2 to 4 times basic salary. Broadly speaking, they're right, but there are a few twists that they need to be fully aware of, which may make them think twice. This benefit is subject to a trust deed and set up under a discretionary trust, and as such, it is up to the trustees as to who receives the benefit. Clients will generally have been asked to make a nomination as to the beneficiaries of their benefit under what is termed as an expression of wish. However, the trustees make the final decision. Another fact is that some death in service benefits may only be offered if your client has opted in to the occupational scheme that may also be available as a benefit from their employer. However, if your client opts out in favour of their own arrangements, as they are now free to do, they may not even be eligible. Do they understand this or even know? Another well-known fact is that death in service benefits are declared to be tax-free, and that is sometimes seen as an added incentive to join the occupational scheme. Make no mistake, they are payable tax-free. However, the problem is that we all tend to nominate a loved one as a beneficiary, and 90% of the time it's a spouse or partner. The fact that it is paid out via a trust, if that's indeed what happens, removes it from the deceased's estate and so is tax-free. However, it then enters the estate of the beneficiary, and if upon their death they have exhausted the threshold for inheritance tax, it then becomes subject to 40% for every £1 they are over the inheritance tax threshold. Worse than that would be if the death in service benefit is payable from the occupational pension scheme. Then it would be counted towards the individual's lifetime allowance, currently set at 1 million, and so would then be taxed at a rate of 55% for every £1 they are over this threshold, if when calculated the death in service benefit breaches 1 million. Then of course, There is the issue that if the individual takes up new employment, there is no guarantee that there is death in service benefits available to them ongoing, or if there is, then that is paid out in the same way as the previous employer. There is also the issue of when it becomes payable. Will it be in a way and time frame that allows for any payment to be used for mortgage redemption when it is needed, or will it be delayed for months on end? In some instances, the trustees may even decide that any lump sum is not paid and instead decide to provide an income with it, which would absolutely put the cat among the pigeons. How would they then redeem the mortgage? Or what if they fell behind and couldn't afford it? It is at this point, perhaps, you should remind them of the mortgage wealth warning. Your home is at risk if you do not keep up repayments on a mortgage or other loans secured on it. And all because they did not buy a simple, cost-effective policy. There's no such thing as a free lunch. Hopefully, this has given you an insight into what is available to your clients from the state and dispelled some of the myth surrounding death in service benefit. I think you'll all agree that it falls short of the mark in offering your clients meaningful benefits that they can rely on and utilise to repay their mortgage debt or payments in times of hardship or, sadly, death. There is absolutely no substitute for considering appropriate products that offer the solutions that your clients need, and more importantly, keep them safe and secure. I'll make no apologies for the length of this video, as forewarned is forearmed. Module 3 looks at the kind of solutions that you can offer and how they will best serve your clients. Thank you for watching and indeed listening.